number 55, in the matter of DCH Auto versus the town of Mamaroneck. We'll take a moment, counsel, while your colleagues organize themselves. Good afternoon, counsel.
Good afternoon, Your Honor. Matthew Clifford, Griffin, Coogan, Sulzer, and Horgan for the petitioner appellants, DCH Auto and DCH Investments, Inc. May I reserve 2 minutes for rebuttal, please?
You may, sir.
Thank you, Your Honor.
You're welcome.
In our view, this is a very simple case that has the potential to impact numerous commercial tenants throughout the state. The parties have agreed and stipulated that the property was overassessed for certain years at issue, subject to resolution of the issue under RPTL 524-3 as to whether DCH is the person whose property is assessed or someone authorized in writing by the complainant, officer, or agent to make such statement who has knowledge of the facts stated therein. DCH, pursuant to its lease, is legally obligated to pay all the property taxes and pays the owner's full tax burden. It also possesses the property, and DCH Auto, in its lease, was conferred the right to challenge the property tax assessments throughout the term of the lease. Therefore, we believe, pursuant to RPTL 524-3, that we are the person whose property is assessed. At the time DCH filed the complaints, it was universally accepted in the state that an aggrieved party had standing to bring an administrative action. The RPTL 524-3 delegated to the Commissioner of the Department of Taxation and Finance the responsibility to prepare the complaint form. With that complaint form, they provided instructions.
Was your client required at the time of filing to offer proof that they had the right to bring the suit?
There's no requirement, but we did. The complaints, the 2009 complaint, which was filed by the client on its own, identified us as lessee taxpayer. And all the other complaints, we identified ourselves as tenant legally obligated to pay the taxes.
And did you have to show that pursuant to the lease you were authorized?
There was nothing in the instructions that said that, and in addition, we believe that the municipalities were put on notice, and in addition, under RPTL 525, they have the right to have a hearing, to administer oaths, take proofs, and request documentation.
So when you say that you're the lessee, they're clear that they're not dealing with the owner?
That's correct, and there's no dispute that they knew we were not the owner of the property. Now, in addition to the instructions which indicated that any person whose property is any person who is aggrieved, any person who pays the property taxes can aggrieve the assessment. The Office of Opinion to Council also indicated that a shopping center lessee who's obligated to pay the taxes has the right to administrative and judicial review. In addition, the town's own website, up until April of 2014, adopted the ORP's instructions and the opinion and said that anybody who was aggrieved by the assessment had the right to file a complaint. None of these sources said that the owner must sign the authorization to the complaint or designate the tenant as an agent to act on their behalf.
It sounds to me, counsel, excuse me, that your argument then is that the appellate division ignored what seems to be a long-standing, widespread custom and practice taking place in front of the assessment review boards.
That is correct, Your Honor.
And you know, took everyone by surprise. But the question I keep asking myself is, did they not have the authority to do that? I mean, they have the prerogative to interpret the statute. I'm sure they recognize that aggrieved party is a term that's used elsewhere in the statute, but not in 524. And they made what to me doesn't seem like a particularly outrageous interpretation that person whose property is assessed is not equivalent to aggrieved party.
Well, Your Honor, there's a couple answers to that. First, the statute does not use the word owner, and the case law...
I didn't say owner.
Right, I'm sorry. The case that changed the law in the state was Circulo from the Second Department. It was a tax exemption case, did not involve a net tenant obligated to pay the taxes or authorized by its lease. The appellate division broadly interpreted the statute and inserted the word owner where it did not exist.
Okay.
And this was never an issue in the state before Circulo because everyone understood, based upon the McLean's case, that a tenant legally obligated to pay the taxes had the right to file.
And Circula is also a second department decision, correct?
Circula is a second department decision, and McLean is a third department.
And didn't the second department have the right, have the authority to make that interpretation in Circulo? And I think it's been followed ever since, has it not?
It has not, outside of the second department. There haven't been any decisions that have followed that. What's happening here is that Circulo did not deal with our factual situation. There was no net tenant. The court spoke broadly and used the word owner where it did not exist in the statute. You know, if the legislature had intended to mean owner, they would have put the word owner in the statute. The second department can interpret the statute, but that's subject to this court's review.
And this court
we
has never reviewed 524 before. We've never said what person whose property is being assessed is. We've never defined that term for the second department or for any other department. Isn't that correct?
That's my understanding, that this court did not address that issue in the Largemont Pancake House case. But what I'm trying to convey is that all practitioners knew that we had the right, that a tenant legally obligated to pay the taxes had the right to file. That went back to McLean's. That went back to all the sources I told you that I mentioned. And now Circulo and the case below have eviscerated that, which is why we're...
It seems to me on some level what you're arguing is that the second department's interpretation of the law should bend to the custom and practice out there before the assessment review boards. And my question is, why would it be wrong to require that the custom and practice yield to the second department's interpretation of that statutory?
Because the custom and practice was based upon McLean's decision out of the third department. The opinion of counsel specifically cites to that. And everyone understood that a tenant legally obligated to pay the taxes had the right to file. The second department respectfully took a left turn.
Do you have a property interest in your lease?
We believe we do, Your Honor, by virtue of being legally obligated to pay the taxes and authorized to file. We are essentially the person whose property is assessed.
So let me ask you another thing. The statute also allows for a designated agent to file on behalf of whoever the person whose property is assessed is. Do you qualify, does the lease qualify you as an agent under the statute?
I believe we meet both components, person whose property is assessed. If the court were to find we are not, we are someone who is authorized. The lease conferred upon us the right to challenge the property taxes throughout the term of the lease. So DCH followed McLean.
Let me, counsel, if I can, if we were to disagree with you, do you have an action against the owner? In other words, do you have any other relief?
I believe we do not, Your Honor.
And if we were to hold against you, so that, given your answer, that is devastating, of course, to your client, but doesn't it mean that people will just better articulate their respective rights in future lease agreements?
It could mean that, but it does not.
To address this issue?
It could mean that, but there's probably thousands of leases out there right now that are drafted similarly to ours that are now going to be subject, that are now abrogated if the court holds otherwise. And all those tenants are out of luck. So respondents are now claiming in their papers that the statute has always required an owner to file. And I say respectfully to the town, they've never explained why, if that was the case, they advised people on their website that anyone could file a grievance. Any person aggrieved could file a complaint. None of the cases the respondents cite involved factual circumstances we have here, did not involve a net tenant. The court was not addressing this fact pattern. It dealt with issues unrelated to the identity of the complainant. In addition, the appellate division below held that we did not satisfy the condition precedent. I see my time is up.
You may continue your thoughts.
We did not satisfy the condition precedent. We respectfully disagree with that. To satisfy the condition precedent, the case law has held that the complainant needs to timely file a complaint to the proper officials that identifies the property, states the grounds for review, and states the relief being sought. The complaints here met that standard. and the appellate division nonetheless dismissed the cases on an issue of form, not of the substance of the complaints. Thank you.
Thank you, counsel. Counsel?
Good afternoon, everyone. William Baker Jr. on behalf of the town of Mamaroneck. Sitting with me is Kevin Stout. He represents the village of Mamaroneck. All the respondents wish this court to do is to interpret 524.3 as it is written. And the importance of all this is borne out by the two 19th century cases, Walter and Burke, which have appeared in their brief. And
Well, counsel, let me interrupt you. What are we to make of the fact that it doesn't use the word owner? Obviously, a tenant does have certain property interests, not the full bundle of rights of an owner, but it has certain property interests. What are we to make of the fact that the word owner is not found in the statute?
Your Honor, our obligation is to define what it means, a person whose property is assessed. Didn't use the word owner. I can't change that. I had nothing to do with it. But what is a person whose property is assessed? Well, I think it's pretty clear that the property assessed is the real estate, because the real property tax law only assesses real estate, and a leasehold interest under New York law is a personal property right, not a real estate right. So therefore, the property assessed was the real estate, not the leasehold of DCH Auto. And also, whose property is that? It's the owner, 700 Waverly Avenue Corp., who owns the property. So that's the person whose property is assessed, and that's the person who was supposed to
Counsel.
file the complaint.
Counsel, the legislature used the word owner dozens of times in other sections. So if they really wanted it to mean owner, wouldn't they have just said what they wanted to mean?
They certainly could have done that, and if they had done that, Mr. Clifford and I would not have had to drive 135 miles to be with you this afternoon. They didn't.
Fair enough.
So we're relegated to interpreting what the words "person whose property is assessed" means, and I submit to you that it can only be the owner based upon the structure of the real property
Do
tax
you
law.
dispute that the tenants are aggrieved?
Well, they have the right to bring on the Article 7 proceeding if a proper grievance had been filed. But there wasn't a proper grievance filed here, except in 2014.
Counsel, I'm sorry, here. To that point, let's assume we agree with your definition of who has standing in Article 5. Essentially an owner, person whose property is assessed, essentially an owner. But the point you just made was Article 7's broader, right? So it's an aggrieved person. And Article 7, to me, looking back to Article 5, doesn't have that requirement you're saying. What Article 7 requires is the petition must show that a complaint was made in due time to the proper officers to correct such assessment. And a complaint was made in due time to correct the assessment.
But it was made by a person who
But
didn't
is
have the
that-
right to make it.
But this requirement, as I read Article 7, seems to mean to me that the purpose of this is to exhaust administrative remedies to give the village or the town the opportunity to correct or to negotiate. And that's our Sterling case, right? So this isn't talking about who brought that petition. It's just saying, making sure that it was done. So when you bring the Article 7, and Article 7 is clearly broader, even going by your interpretation,
Absolutely.
all you have to say is the town had notice and an opportunity to address these issues in the administrative process.
But under that logic, Your Honor, you could have filed a grievance.
No, no. You can challenge that,
But the
right?
grievance, that's what we are doing. We're challenging the fact that the person whose property was actually assessed, who turns out to be the owner of the property, did not file the grievance.
But I think, counsel,
Yeah, so, I'm sorry. Okay, I take your point, actually, yes. So I could have filed the original one, and for some reason, Mamaroneck decides we're going to just deal with you. And I come in and I have all my assessment documents, and we negotiate, and you reject my claim, and it goes on. And you never make a motion, you never do anything in the Article 5 proceeding, and you let us go through, and you treat me like I'm a person whose property was aggrieved all through the Article 5 petition. Why not? If you're going to do that, why doesn't that satisfy the Article 7?
Because I think the underlying premise is that the complaint is filed by the appropriate person, not just anybody, but the person who the Article 5 says must file it. the person whose property is assessed. I don't think it just means that anybody at any time can file a Article 5.
One, I think it's
administrative
somewhat
case.
undercut by the fact that the localities aren't challenging that in the Article 5 proceeding. They're raising it 7 years later in an Article 7. But as I read the Article 7, that provision is in there to ensure that the process was filed, that the town had the opportunity to negotiate and to address these issues in the administrative proceeding. It's not a jurisdictional basis.
Oh, I disagree with you. I'm sorry, Judge Garcia. I think the whole fundamental premise is that the proper person comes to the Board of Assessment Review. That's the whole premise.
And is there
Not
no,
that
is there
anybody can-
no duty on you to point out that it's the wrong person, if you believe that?
I don't believe there is any such duty to do that. None whatsoever. It's up to the petitioner, or the complainant, I should say, to establish their own jurisdiction. It's not up to me as the respondent to tell them where they might have gone astray. And what I wanted to get at is these two 19th century cases. I want to get back to that. It turns out that those two 19th century cases that are Court of Appeals cases dealt with an 1858 statute, which I finally was able to get my hands on. And that statute had nothing to do with tax certiorari. It had to do with assessments that were being levied against property by the city of New York pre-Civil War, as it was putting in sidewalks and streets in front of people's homes, and therefore assessing them. That statute had no grievance procedure. It allowed an aggrieved party, which this court interpreted to include lessees in those two cases, Burke and Walter, to go directly to court. Now, why is that important? Well, because those two cases, which were not tax certiorari cases, and which did not involve administrative review, were then cited and relied upon by the McLean decision that Mr. Clifford refers to as the reason why in the city of Binghamton, under its local law, a tenant could file a grievance. It then McLean is cited in the opinion of the State Board of Equalization and Assessment that Mr. Clifford has cited, involving a lessee of a shopping center being entitled to file a grievance. Then it's cited by this court in the tax certiorari case in 1989, Wall Bounds. And then it's cited by this court in the Larchmont Pancake House decision, both by the majority and by the dissenters. So my point is that the incorrect premise of these two cases has now permeated into the tax certiorari world and influenced it in a way that it should never have been done. And I just wanted to point it out to the court. I have copies of the 1858 case law with me. I'm happy to leave them with you, and of course I'll give Mr. Clifford a copy. The problem also is the notion of laws of what language being superfluous. As you know, 524.3 and 704.1 contain completely different phrases. Person whose property is assessed versus any person claiming to be aggrieved by an assessment. These two phrases have only one word in common, person, and a version of the word assessed. You have always told us that statutes have to be construed, and I think your Mistecki decision says it best, that meaning and effect should be given to every word of a statute, and that an interpretation that renders words or clauses superfluous should be rejected. That's the Mistecki case. You go on to say more recently in Irondequoit versus the County of Monroe that the courts must look at statutes in such a way that harmonizes related provisions and renders them compatible. That's what the Second Department did. It said, we have these two phrases, they're completely different, they must mean different things. 524 should be interpreted to mean the owner, and 704, a much broader group, as Judge Garcia has pointed out to us.
Counsel, just on that point, I don't know the answer to this. What is the policy reason for doing that? For giving a broader group access to Article 7 than those that could bring in Article 5?
I do not know. I suppose it has something to do with the fact of It has something to do with the fact that the tenants are paying the taxes, there are no two ways about that. So there may be that rationale, but I think the rationale for having the owner file the grievance is so that it stays involved in some way in the overall process, so it's aware of what's going on. I will end with this if I might.
So I'm sorry, let me interrupt you there. Are you saying that the way to harmonize it, in response to Judge Garcia's question, is that the legislature wanted to ensure that a tenant wasn't acting without consent of the owner? Is that what you mean by
Without
that?
knowledge, at least.
I'm sorry.
Without the knowledge of the owner.
Yeah, but knowledge, unless you approve of it, is not helpful to you here, I think.
Not really, because this particular lease on page 456 of the record requires the landlord to get involved if the law requires them to get involved. So they've already negotiated a lease that covers this contingency. They just didn't utilize that.
Let me ask you this, and it may be a silly question. Let's say a tenant brings the action, and the landlord, the owner, has no knowledge of it, and the tenant loses. You've taken no, the town has not acted on it, hasn't said you're not the right party, and in fact makes a determination and says our assessment was correct, you lose. Can the owner then say that's null and void because I'm the only one who can bring the action?
No, because there are strict statutes of limitations. You have to file a grievance within,
Well, let's say it's within the statute of limitations.
I don't see how that possibly could happen.
Okay.
Now, I just want to, I know I'm over my time, but one last point. I've been at this since the fall of 2018, when the make-I motions were being made in the Watchman Pancake House case. The International Council of Shopping Centers was one of those amici then, they're amici now. They have 4,250 members in the state of New York. In these 3.5 years, I have not seen an affidavit from anybody that says, I'm a tenant required to pay lease, the taxes. I went to my landlord, asked my landlord to sign a grievance, and my landlord refused. So the apocalypse that's being portrayed by the petitioner and its allies just does not come to pass. With that, I end and wish you all a very pleasant afternoon.
Thank you, sir. Counsel?
Thank you, Your Honor. With all due respect to my colleague, at the time we filed, the law didn't require the owner. Sir Kilo came in down the stream, changed the rules. We relied upon all the sources, the state guidance, the town's website, and the Claims case. In addition, when the court is reviewing this particular statute, it's remedial in character and should be liberally construed so as not to defeat a valid claim on a technicality. And we believe that's exactly what happened here. In addition, with respect to the construction, we believe that the canon of in par materia applies here because 524, 704, and 706 of the RPTL all relate to the same subject matter, and that's the review of property tax assessments. RPTL 524 and 706 present the same grounds for review. And as Judge Garcia pointed out, the filing of an Article 5 complaint is a condition precedent to the Article 7 petition. The statutes are interlocking, they're interdependent, and they should be construed together. We believe that the second department respectfully inserted an owner requirement where none existed before, and if that is upheld, it is going to cause chaos out amongst tenants who have leases structured the way ours is. Now,
But let me ask you this, if moving forward prospectively now, the law is clear, why isn't he right that tenants could simply go to the owner and say, you got to file that complaint, and if they refuse, then maybe you have an action against the owner?
If the court changes the law now prospectively,
Yes.
I think that might be right, but retroactively, which was applied here, there's a condition by...
Yes, I understand it would not
Wouldn't help us.
give you comfort.
Right.
But I'm saying in terms, because before I asked you a question about whether or not there might be some remedy, and you said, no, these leases are set in stone, there's no remedy. So the question is, if they have these provisions, and we now say, moving forward, the law is that the owner is the one who's got to file the complaint and has got to move forward on these actions, that would allow the tenant, right? My point is that would allow the tenant, given if the lease has that language, or otherwise to argue to the owner, you're the only one who can do this, you must file a complaint.
I think that would reach an equitable result prospectively. Here, it would not be equitable.
Yes.
Thank
could
you,
just-
counsel.
Thank you.